after the interception, extradition, and re-arraignment of the leader of the outlawed Indigenous People of Biafra, Nnamdi Kanu, by the federal government last week. He was granted access to his counsel, Ifeanyi Ejiofor. Mr. Ejiofor will now be joining us from Abuja to discuss the legal battle ahead as he seeks to defend his client against the weighty charges that have been preferred against him by the Nigerian state. Good morning, Ifeanyi Ejiofor, and welcome to the morning show. Great pleasure to have you joining us this morning. Hello.
Good morning, Mr. Abati. So much. It's a pleasure meeting. It's a pleasure being in your platform this morning. Thank you so much, Mr. Abati.
Thank you very much. Well, Ifeanyi Ejiofor, you are counsel to Nnamdi Kanu, and you'll be quoted in the papers saying that your client has been badly treated, not just by the Nigerian authorities, but also the Kenyan authorities involved in the entire saga. Although the government of Kenya has pleaded innocence in all of this, saying that they were not involved in any way whatsoever. What are the issues involved in terms of the procedure adopted by the Nigerian government and the extent of the involvement of the Kenyan authorities? If you may just present your case.
Thank you so much, Mr. Abati. Let's go straight to the point. Well, I have a number of issues I wanted to address in the course of this discourse. First of all, there was a clear collaboration between the Kenyan government and Nigerian government. I'm happy now that they are denying the fact that Nnamdi Kanu was arrested in their place and also handed over to Nigerian government. But I can assure you that by the time we finish with them at the international court, they will never remain the same. What's important at this stage, and I've already made known to the world, is that he was arrested at the airport on the 19th day of June 2021. And he was taken to an unknown residence. That is a fact. He wasn't taken to a custody, and they recognized the official custody of the police over there. He was taken to an unknown residence where he was subjected to inhuman treatment. Nnamdi Kanu was tortured, maltreated, and beaten, mercilessly beaten. So these are facts within our knowledge confirmed by him to us. So after spending 8 days in their custody, illegal custody, they now beckoned on the Nigerian counterpart to come for him. And by the time they came, Nnamdi Kanu was apparently unconscious at the point they came to pick him. He was unconscious. He was near lifeless at the time they were back taking him to Nigeria. So, and consequently, they brought him here. So now, to tell you the level of their conspiracy and the desperation to get him jailed at all costs by enemies, they brought him here on a Sunday, and the federal government is fully aware that I'm the lead counsel to Nnamdi Kanu. And there's a charge against him before the court, which has been subsisting has been going on, because after invasion of his premises on the 14th of September 2017 by the Nigerian military and soldiers, who killed over 28 persons in his house, and by act of providence he was narrowly escaped, we filed an application before the court for an inquest into what transpired in his house on the 17th of September 2017. For court to inquire as to what happened in his house, what led to his disappearance. And we are still in this process, because that is fundamental. This is a person that has expressed to the world that he's ready to come for his trial on October 14th, 2017. He wasn't planning to leave the country. He wasn't planning to run away from the trial. He was ready to come for the trial on October 14th. The matter was stated for commencement of trial. Then on September 17th, his house was invaded. So to tell you that the government was not ready at the time to prosecute him, because they have no evidence to establish even the charge preferred against him to even date. So they went after his life. Now it's compelling on the part of the court to inquire what happened to this person I granted bail. What led to his disappearance? Then surprisingly, on the 28th of March 2019, when the matter came up for sureties to show cause why they will not be committed for contempt, why they were unable to produce Nnamdi Kanu, That was the proceedings of that day. The court gave an order revoking his bail. Then we said no, because the court should be bound by its records. We said no, and we filed an application to get order vacated. Since 2019 to date, the matter had severally come up before the court, the same court. And the court was not inclined to hear this application to vacate the order. And the worst thing is that the federal government has not filed any response to this application before the court. They've not filed a response in counter to application to get order vacated. They were not interested. What they are interested is to how to get in Nnamdi Kanu at all means available to them. So now, he was brought into this country on Sunday after being detained, maltreated, subjected to all forms of injury, maltreated, and inflicted with severe injuries on account of handcuff that lasted on his hands for over 4 hours till before he was brought to court. And you can see him on handcuff in court on that day. Those injuries are still there. And a number of medical issues he's having today on account of what was the kind of treatment that was meted out to him. So they took him to court on a Tuesday. Labaran, who is the counsel that was in court on that day representing federal government, is fully aware that Ifeanyi Ejiofor is the lead counsel in this matter. And I've been in court with him in all cases affecting Nnamdi Kanu and IPOB. He never extended the courtesy of informing me that that my client was arrested, was abducted, because in this case wasn't arrested. So, but when we get to that bridge, we'll cross it. He was abducted and kidnapped from Kenya and brought into this country. So now he didn't feel it confident, didn't see it confident or deem it appropriate to inform me that my client was arrested and has been brought to court on Tuesday. So that shows there's a collaboration between the government in question, as we stand today, and the people who were appearing before them. Because if after all there was any element of iota of transparency in what they're doing, is compelling on the part of the AG, not the lawyer representing the Federation, to inform me that they are coming to court on Tuesday, so I can come to court and see my client. I don't know what happened, and this is quite from him what happened. So on Tuesday, they took him to court, and the court asked them, "Where is Barrister Ejiofor? Is he not in court? Was he not informed?" They said no. They arrested him and brought him to Abuja on Sunday, and he's called today. So now there's an underlying fact that my client will not get fair trial in that court. That's settled. The issue of fair trial has been taken away by this collaboration. But we keep on watching. We are going to see them in court. So that is what happened as of today. I've seen him, and he has given me every information and detail about what transpired in Kenya, how he was arrested, how he was taken to a non-destination, and how he was maltreated, how they nearly killed him over there. And it's obviously from what he told me that it was at the behest of the federal government that they were doing those things. So until when they beckon on them to come. These are against an obvious infraction to all international laws and treaties. So but at that level, we're addressing it. We're going to address an international court at that level. So let me concern myself what's happening in the country. So it's obvious from every indication that my client will not get a fair trial in this court. Obvious. Until when the contrary is established. And now, Nnamdi Kanu was remanded in prison custody. Let me underline this fact. Long before he was granted bail, he spent over 2 years in custody before he was granted bail. The court itself is aware that he was in prison custody before he was granted bail. And at the point he was in prison custody, Nnamdi Kanu never at any point in time made any effort to leave the prison without the judicial process. Now, they remanded him in DSL custody, where they made it near impossible for his relatives which are to visit him, except on appointment by his lawyers. So that itself has also graduated to what I call mental torture. He's being subjected to mental torture as I speak to you now. Because when somebody is in incarceration as a political prisoner, which is, he has no access to his wife, he has no access to his brothers, he has no access to relatives to discuss with them and interact with them. Even lawyers who are coming to see him are coming on a specific approval by the DGSSS. So it shows that he is undergoing mental torture. And it is worse still when Nnamdi Kanu is he is under a debilitating health situation. He has a medical condition that needs to be addressed as quick as possible. Because it's only a living that can face trial. So this, I can stop at this time to come up with a second question. Thank you.
Wow, you've given us quite a lot to unpack. I want to start off with Kenya, because you've said you're going to address that in an international court. But Kenya's extradition laws make it quite clear the kind of offenses, the nature of offenses for which extradition can be granted. There's a list, and treasonable felony is not in that list. In fact, the law in Kenya, the extradition law, states that fugitives are not to be surrendered if the offense is of a political character. So you mentioned the charges proffered against your clients. Has the Nigerian government now expanded the range of charges levied against your client? That's my first question. What are the charges that Nnamdi Kanu is facing now? My second question, you've said that you don't feel that your client will get a fair trial in Nigeria, but he has been given access to you, his legal representative. What else would you need to see to convince you that a fair trial is possible, as is his right under Section 36 of the Nigerian Constitution?
Thank you so much. You will recall that on the day he was taken to court, that was last week, Tuesday, Nnamdi Kanu was allowed to address the court because I was not in court. I was not in court. So that enough shows you that's the problem. Nnamdi Kanu is not a lawyer. And he has no competent to address the court. He might address the court. Because if needful was done, I would have been in court to address the court. And also apply to the court that he should be remanded in prison custody. So that is a clear violation of his constitutional right to a fair trial. So because I was not in court, he was allowed to address the court. So that shows you that there is more to it than meet the eyes. Because Labaran has my number. The office of AG has my number. They have simply put on a call across to me that they've abducted, whatever they call it, they classify it as my client somewhere in Kenya. I'm brought into here. And I take him to court on Tuesday to continue his trial. Then I'll be in court on Tuesday. And also convince the court on the reason why he should be sent to prison, to correctional center. But in this case, the court allow him, which is abnormal, which is unethical, allow him to address the court. Why should court be asking him why he run away when I'm not there? We have an application before the court which contains his affidavit on oath, deposed before a commissioner for oath in Israel, stating the facts of what transpired in his house on September 17, September 14, 2017. How he nearly escaped death. How he was ready to come to court on 14th of October 2017 to face trial. Then this are before the court, and court never entertained it. Court never entertained it. These are record black and white before the court. Court has never entertained this application before the court. So I will be craving the court or at any adjournment for the court to hear it. Because it's fundamental to his fair trial, to the right. The court should hear and understand what transpired in his house. That's very fundamental. Then the court is now allowed to address the court on these facts, which are already before the court. So that's area why I'm entertaining fear that he will be granted a fair trial in this court. So now, coming to what happened in court, the matter has now been adjourned to 26th of October, to 6th of July, 2021.
Ejiofor.
Let me say this to you.
Ejiofor, sorry to interrupt you. We need to take a short break. When we take a short break, I see you are very passionate about this. But we're going to unpack all of those issues. And there will be more than enough time to do so. So we'll take this short break and we'll come back to you. Please stay with us. Welcome back to the morning show here on the Arise News channel. Our guest is still Ifeanyi Ejiofor, counsel to the leader of the Indigenous Peoples of Biafra, Nnamdi Kanu. Well, Ifeanyi, yes, you said a lot, and we've listened to you, but we would like you to conclude your thoughts on what you were saying. But take this along with some of the things you wanted to say. First, you were accusing the Kenyan authorities. But aren't we dealing here with the case of a fugitive from the law? A fugitive from the law who was also organizing against the Nigerian state along borders. I'm sure as counsel, you are familiar with what is called cross-border crime, transnational crime under public international law, and the role of Interpol in that regard. Second, the Court of Justice Binta Nyako, when your client was brought before the court, and then he was remanded in the custody of DSS. The court specifically, Justice Nyako that is, asked that you should be contacted, the counsel should be contacted. But you were saying no attempt was made to get across to you with a phone call. But I thought that the Court of Justice Nyako protected your interests by saying that going forward, when the Lordship announced the adjournment to July 26, talked about counsel for the defendant appearing in court. And you are talking about bail. You are talking about medical condition. Now, do you think that your client is in a safe place to ask, for further bail, given the fact that he became a fugitive from the law? The rationalization that you gave may not be tenable before the court.
Thank you, Mr. Bathy. I respect you so much. Let me just, it's important for us to correct an impression at this stage. My client is only a fugitive in the eyes of Nigerian law or court. So the prescription of IPOB has never been endorsed by any country of the world, including any of African countries. So there is only a recognized or probably given credence by the Nigerian courts and laws. So let me address the fourth part. We have proceeding. We have what I call extradition proceedings. The fact that he was allegedly committed a problem or probably on a warrant to be arrested cannot stop the country from going into what they call extradition proceedings. Before it can be, his extradition can be granted by that country. And you have heard it see that even the offenses he was being charged of at the time he was abducted from Kenya did not fall within the items specified under the Kenyan laws as those offenses that can be held under extradition proceedings. It's clear. So what we are saying is that it's subjective to Nigerian opinion. It's a law. It's a fugitive in Nigerian court. Why is it that no country of the world has endorsed IPOB as a terrorist organization? Because they are fully aware of my correspondence with them across the world that IPOB is a legal organization. IPOB is not is a non-violent organization. And the order of the court obtained through the back door is being challenged before the Court of Appeal today. So they will allow the proceedings before the Court of Appeal to end because we filed an appeal against that order timelessly, challenging the prosecution of IPOB. Now, the federal government took them almost a year and 8 months to respond to all applications so filed before the Court of Appeal. That notwithstanding, we still submitted to a delay. We never oppose the delay. And it's also when we have an application for stay of proceedings before the Court of Appeal. And also have an application to stop them from executing that order. So these are applications before the Court of Appeal. And they've been run away from the court. I can confirm that to you. I have documented this case file. They've been run away from the court. I'll tell you when they file their respondent brief. Even on the day they file a motion for them to enter appearance out of time, or for their brief to be accepted out of time, we file our reply to their brief on the same day in Court of Appeal, expecting the court to allow us to hear our appeal. And the court didn't hear it. The court didn't hear it. The panel constituted to hear appeal didn't hear it. About 10 o'clock, they send a message across to us that the court will not be sitting till date. So now, coming to the aspect of not informing me before he was taken to court, I'm not talking about what transpired in open court. I'm talking about the duty on the prosecution, on the part of the prosecution in this case, to call me when he was arrested and inform me, because he owed me that compelling obligation to inform me and tell me that the matter is called, my client has been arrested or abducted, whatever you call it. Then he'll be taken to court on Tuesday. Then I'll be in court to address the court on some issues, not to my client allowed to be asked to address the court. So, and the court is fully aware that he was coming to court on that Tuesday. Because if you watch the proceedings that took place on that day, president of the court, he never lasted for more than 10 minutes or 15 minutes. He never. He was just brought to court and informed the court, they transferred him to DS custody. The press were stopped from seeing him, from interviewing him. He was blindfolded. So tell me what offense has he committed? Even in the eyes of Nigerian law, Nnamdi Kanu is still presumed innocent today. He's still presumed innocent by virtue of Section 35(6) of the Constitution. So he's still presumed innocent today of all allegations against him. So he's being subjugated as we speak now. Of course, you know, a lot of things are going on. Both media trials. People are being paid to come and confess and say some things against Nnamdi Kanu. But I don't think I have any issue with that one. When we get to court, we'll address it. Media trials are ongoing. Somebody will come and tell the world that I'm an ESM member. I was admitted so that Nnamdi Kanu said this. It's an open court that we have to establish that thing. So we have to be circumspect on the media trial going on against Nnamdi Kanu because he has been abducted and brought to Nigeria. So what my challenge and my concerns is stem from the fact that I was not informed that he was arrested. 1, 2, I was not informed that he was being taken to court on a Tuesday. So I believe the Rabalan Shaibu is under compelling you to tell me because we are sending correspondence and I have my number. I have no number.
If you can hear me real quickly. So what happens on the 26th? A lot of people you're talking about bail now. You're talking about the fact that he's got medical condition, he should get bail. But on the other side, on the side of the government, what they're saying is he's jumped bail before. So how will it be easy for you to be able to prove that case that someone that has jumped bail before you will let go? You're also saying that they should put him in prison and take him out of GSS custody. Are those going to be the things you're going to be pushing on the 26th when you get back to court?
Thank you, Rufai. What I'm saying is that in the first place, Nnamdi Kanu never jumped bail. Let it be clear to everybody. He never jumped bail. Because if the federal government was serious about prosecuting Nnamdi Kanu, if they're serious about prosecuting him, they will allow him to come to court on September 14th, 2017, October 14th, 2017, to face his trial. Are you telling me that soldiers that invaded Nnamdi Kanu properties are not from Abuja? Are they acting where they acted under the instruction of someone in Abia State? The answer is no. They came from Abuja, they have the instruction of the federal government to go to his house. So they are fully aware that Nnamdi Kanu was scheduled to be in court on October 14th. And in one of his broadcasts prior to the invasion of his premises, he told the world that he's coming to court with over 1 million members of IPOB. He informed the court, told the world. So why didn't they allow him, if they have any case against him, to come to the court on October 14th? Probably at the end of the proceedings, they will arrest him. So he never jumped back. This is the person, okay, assuming without considering to the fact that they succeeded in killing him on 14th of October, on September 14th, when they invaded his premises, will we be talking about his trial today or not? The answer is no. Because it's only a living that can face trial, and nothing more. If he was abducted, they succeeded in abducting him on that day they invaded his premises and killed over 28 persons, civilians or armed civilians, then we shouldn't be talking about what they're saying today. So, but by act of providence, he will never escape being killed. So these are people who are fully aware that he was scheduled to be in court on October 14th for his trial. And in Abuja here. So why can't you wait for him to come to court if I have any case against him? So, and we have supplied the court these facts. We have supplied the court circumstances that led to his disappearance from court. We have informed the court and convincingly that Nnamdi Kanu was ready to start his trial. But for the fact that his life is under threat. So the court is under compelling obligation to listen to the applications before him.
Okay.
And make findings or decisions one way or the other.
Right. If I may come in here.
So he didn't jump bail. He wasn't to come to court.
Okay, according to you, he didn't jump bail, but did he or did he not violate the bail conditions that he was given? Because you recall, the bail conditions were stringent. He was not to hold rallies or have meetings, which he did.
Thank you so much, my sister. Let me say this to you, because it's important for us to inform you appropriately. And whatever I'm saying today to you today, I will furnish you with documents to that effect, black and white. Before the date slated for his trial, the federal government, acting through the Attorney General of Federation, filed an application to vacate his bail, to vacate his bail, right? On the premise that he has violated his bail condition. This application was filed in black and white and served on me. And I responded to that application because it's a matter for court to decide. We cannot at this stage, at that point in time, or probably during that period, determine when Nnamdi Kanu violates his bail condition or not. And also, I want you to appreciate the fact that I had also filed an application to validate their bail condition before they file their own. So this is a pending application before the court. The court for the court to hear my application to vary his bail condition, hear the one filed by the federal government that he has violated the bail condition, and also hear the one I filed in reply to what the federal government filed, stating that Nnamdi Kanu never violated his bail condition. So they're supposed to hear those applications because it's under our duty to hear those applications and make decisions one way or the other. So it is not in our it's not within our rights today to state that Nnamdi Kanu violated his bail condition at that time, point in time, because we have application before the court for the court to hear and determine. So I still maintain today that Nnamdi Kanu never violated any bail condition.
Anyway, Mr.
Because we have application before the court to vary it. Also,
Mr. Ejiofor, your point is clear. But before we go, you said you are going back to the court to do the needful. Will you define for us and for the benefit of our viewers what you mean by doing the needful? What will be your prayers before the court when you show up there on July 26th?
Mr. Ruben Nabati, thank you so much. What I want to say to that effect is that we have already filed applications are going into the court today. Because we have preliminary application we need to file entertained by the court before the 26th of July. As I speak to you, his care condition is deteriorating every day. So, and that need to be addressed as quick as possible. That need to be addressed because it's only a living that can face trial. If anything happened to Nnamdi Kanu before the 26th of July 2021, the matter is slated for hearing. That means the trial will not go on. So, they need to be attended to as quick as possible. And we are going to court to get an order of court to ensure that he's given attention. That's fundamental. Because his life first before we talk about trial. So that's what I mean by needful, doing the needful. We're going back to the court to do the needful. Then I've had a number of places where they're saying about amendment of charges. I have no problem with that. Let them submit the amended charge. Right?
Yeah.
So, and also, let me use this opportunity to appeal to you. And also appeal to the world. To tell the government that I have to be protected. Because my life is under threat as I speak to you as his lawyer. Attempt has made as my life. People were killing my premises. I cannot move. I cannot sleep now with two eyes closed. So let the world intervene in this case. Because I must be given protection to defend my client. I don't know what I've done to deserve to be killed. Because I'm defending IPOB. It's within my constitutional right as a lawyer to defend anybody that come across me. And I'm doing justice to that. So let me use this opportunity and this platform to appeal to the world to prevent the federal government to protect my life. To stop those who are hell-bent on killing me.
Okay.
They have been looking for me all over the place to kill. Not that I've committed an offense unto law, but that they want to assassinate me at all costs, my enemies. Thank you so much.
Okay, Mr. Ejiofor, real quickly, have those threats, like you talked about, been reported to the police? And secondly, what are these new charges against Nnamdi Kanu?
What I understand that happened is that, before Nnamdi Kanu was arraigned in 2015, we have, first of all, they started with about 3-count charge. Then subsequently after that, they filed an amended charge of 11-count charge. And we filed an objection to that charge, to the 11-count charge preferred against him. And the court struck out 8 out of that 11, remaining 3. So, and even in the court ruling, which I will make available to your people, the court made a remark that even the 3-count charge still pending against Nnamdi Kanu as Kanu, that the proof evidence before the court cannot even substantiate that charge. Cannot substantiate it because they are porous. So, but for the benefit of that, it's giving the prosecution the benefit to come forward with their witnesses to establish this charge against him. So now, what we are seeing today is that those charges, the court struck out, has been referred by the federal government. That's what we're seeing today. The charge, the federal government, the court has struck out, the 8-count charge, the court has struck out sometime in the course of the proceeding, has been referred, resurrected by the federal government again. But my brother, we have no problem. We know that Nnamdi Kanu, the whole world know, is a political prisoner. So we know he's a political prisoner, and we are going to impanel a fortified legal team for him. And in court, we resolve every aspect of items of the charge they're bringing before the court. We're not running away from the court. We believe in judicial process. We have implicit confidence in the judicial process. So, but when things are going wrong, I will inform the world, because I must be alive to my duties.
I mean, what are these charges? You've not specifically, stated these charges so that the world can know. These these charges that have been brought back, like you said, what are these charges?
It's an old charges. I may not be able to rephrase offhand. Has to do with possession of illegal equipment belonging to unlawful society, and recall that at the point they filed this charge, they charge him with belonging to unlawful society. IPOB has not been proscribed at that time. And the court stated in his ruling that IPOB at the time is not an unlawful society. So, on the strength of that order, they stop arresting IPOB members when they come to court. So, and to make things easy for them, they went back to the court. And without a knowledge, obtain an order to prescribe IPOB, which are challenging before the Court of Appeal today. So, these are charges they filed, belonging to protection of materials, and also other offenses are not be stated up front.
I don't think the issue is about the 11-count charge. Those ones are in the public domain. Recently, we were told that the government is going to amend the charges, add more charges, including murder charges. Now, have you been informed? Have you been apprised of that? Because, previously, the biggest charge was treasonable felony, which carries the maximum of life imprisonment. But if murder charges are going to be added, then that's a capital offense. That will carry the death penalty. So are you aware of this amendment, of these additional charges? Have you been informed ahead? And as for Kenya, that you've been talking about, the High Commissioner of Kenya to Nigeria insists that, in fact, it's derogatory, it's insulting, it's malicious, and it's defamatory of the person of the President of Kenya for anybody to suggest that Kenya was involved in any other way. And that was why I asked you the question about trans-border crime, transnational crime, cross-border crime, and whether, in fact, what we're dealing with here is Interpol working directly with the Nigerian government.
Okay, Mr. Abati, for the benefit of that, let me just spare some time and address you on this point. I wanted not to say it, but let me just say for the benefit of that, for the world to know. When Nnamdi Kanu was arrested, abducted in Kenya by the Kenya police force at airport, he was primarily accused by the people that arrested him of committing treasonable offense in their country. And at the point in time, they were apparently or presupposedly acting under the impression that they don't know the person they're dealing with. So now the game changed when they took him to a place around the police station or any of the approved official detention facility of the Kenya government. They took him there and started maltreating him. So they were discussing with him, interrogating him on the basis that he has committed offense against the Kenyan government. So I am telling you what I have with me, the impeccable facts I have with me. And I have every evidence to establish that in the course of time. Because when we get to that international court, the Kenyan government will come to defend themselves. We'll have facts, information, documents to show what happened to him and where it happened. So, and when they became convinced after 8 days of maltreating him, torturing him, subjecting him to all forms of inhuman treatment, that Nnamdi Kanu never committed any offense unto law in Kenya, a British citizen for that matter. Then they ran back on because it's a collaborative something. It's like there was a conspiracy in the first place. So because they know probably he has meetings, he will be attending a meeting in Kenya. So they have that intel. So they ran back on the Nigerian government to come and pick him without due process of law being adhered to. So if he has committed any offense unto law over there, remember he's a British citizen, they were subjected to extradition proceedings. So this took place in Kenya. And we have the facts, we have documents to show to the international community and in the fullness of time. As I speak to you, I'm written to foreign government. His attorney in overseas are taking up the matter over there. So they're being smart by half for denying the fact that Nnamdi Kanu was never arrested in Kenya. Let them go to court. We're already in court with them. They're taking them to court anymore from now on what transpired in Kenya. That he was abducted, taken to non-residence, maltreated, beaten mercilessly, tortured. So even as a matter of fact, when the Nigerian counterpart came, they became scared of the fact that Nnamdi Kanu might have died in their may have died in their hide if they didn't conduct proper examination, medical examination. That was when they took him to a hospital in Nairobi and confirmed what his medical situation. So as I kept on to emphasize that his medical condition is deteriorating every day. And I'm telling the world that it is better for him to be given medical attention than to die before the date of the hearing. And if anything happens to him today, he's today before the Nigerian court. He's today before the Nigerian court, in Nigerian custody. Nigerian government will be held responsible. So they should they should allow his medical expert to visit him and give him attention.
Well,
and also face his trial. We're not against the trial. Let's go on.
Yeah, look, I get the impression when you keep referring to British citizenship in Kanu's case, as if British citizenship is superior to Nigerian citizenship. Is that the case? And I still ask you about those additional charges. Have you been informed about what those additional charges are at this point?
Thank you so much. Mr. Batty, there was as I speak to you, there's no additional charges against Nnamdi Kanu. So it's being speculated over the media. I will be in a position to confirm to you that the federal government has amended the charges preferred against him to include charge of case of murder. And you see, one thing, we operate accusatorial system of government jurisprudence. So let them come to court and establish whatever crime he committed. I have no problem with that. Prefer a charge of any magnitude, I have no problem. It's one thing to say somebody committed an offense, then another thing to establish the items, ingredients of those offenses before the court. But so as I speak to you, I've not been served with any amended charge against him. I've not been informed that they filed a charge against him before the Federal High Court. So right. What you are hearing over the social media are mere speculative, as I can confirm that to you.
Right, Mr. Ejiofor, you know the binding effect of legal precedent. So I want to remind you of Asari Dokubo and the Federal Republic of Nigeria, where the court upheld the corporate existence of Nigeria as indivisible, indissoluble, a harmonious sovereign state, such that the rights of the individuals are suspended when it comes to national security. What is your comment on that ratio in the context of Nnamdi Kanu's case?
The Asari Dokubo's case has to do, what they are relying to, has to do, it has to do with application for his bail, when application for his bail was made. And that was the ground upon which the court said they cannot grant him bail. So, but in this case, we have not made an application for his bail in this instance. We are talking about his health condition. And I am not saying that you release him to go and attend to himself, attend to medical challenges. What I'm saying, in effect, is that they should allow his experts. He has medical doctors who will come and attend to him where he is. Then we will not go back to court. So we're not started applying for bail now before the court. So what you are talking about, for him to be given immediate medical attention to avoid dying in custody, because his health is deteriorating every day on account of the torture meted out to him in Kenya, and the extension of the torture here, because by keeping him in solitary confinement amount to grievous torture. So when we get to the bridge on the cases you cited, we'll cross it. I have no problem. We've been in the matter since 2015, and I can assure you the federal government have no evidence to establish any case against Nnamdi Kanu.
Okay.
As a matter of fact,
real quickly, interesting turn, Barrister Ejiofor. You talked about him being taken to a hospital in Kenya. You said there was a medical report out of there. Is there anything we need to know as regards that? Because now you are saying that same medical report is based on what you're talking about, that is ill health, and that's why you're asking for a bail. Or you want his experts, a medical expert, to come see him. Is there anything we need to know about that medical report out of Kenya?
What I'm saying is that the medical report in Kenya is where he was examined, briefly examined before being brought to Nigeria, is clear. And we are pursuing it over there. So let me hope that Kenyan government will not also compromise in this regard, because we have records to that effect. So, but what I'm saying is that Nnamdi Kanu health condition is in a terrible state. So, and we are appealing to the government of the state. the government of the Nigerian government, to allow his medical doctors to examine him where he's being kept. So I don't want to go into the details of what is contained in his medical report now. So, but in the course of time, you will get to hear all. But I've told you as a lawyer, as his lawyer, whom he has narrated everything to, the circumstance that led to his arrest, what was done to him, and also where he was kept. Terrible environment he was kept for 8 days before being brought to Nigeria. So we have those facts with us and other compelling evidence we may not like to make public now at this stage until when we get to that bridge. So what I'm saying is for them to allow his medical expert to examine him and give him attention now. Because we have no confidence in the system where he's being kept.
We've run out of time, but I still recall that you didn't answer that question about whether being a British citizen is superior to being a Nigerian citizen, and whether Nnamdi Kanu is no longer a Nigerian citizen, and whether a British citizen can do as he wishes within Nigerian territory. But in any case, we'll leave that hanging. Thank you very much for joining us on The Morning Show.